Ready, start. An agreement was executed on 17th November 1992 by and between the appellant and the respondent. Full stop. Under the said agreement, the respondent agreed to design, procure, manufacture and supply to the appellant machinery and equipment for a continuous fermentation process based on the Insilium process, patented by the National Chemical Laboratory, Pune. Full stop. The agreement contained an arbitration clause. Full stop. The total consideration was of rupees 93,20,000. Full stop. One of the clauses in the agreement was that the fermentation plant that was to be supplied by the respondent must have a guaranteed minimum yield of 280 liters of alcohol per metric ton of molasses. Full stop. According to the appellant's case, when the agreement was entered into, the existing yield in their factory was 245 liters per metric ton of molasses. Full stop. Under the agreement, the plant and machinery were to be supplied within a period of 5.5 months from the effective date of the agreement, that is, by 15th May 1993, for a total consideration of rupees 93.20 lakhs. Full stop. According to the appellant, there was a delay of about 24 weeks in the delivery of the machinery. Full stop. The appellant's case was that 4 trial runs were conducted on the machinery supplied by the respondent. Full stop. The yield was much less than the guaranteed yield of 280 liters per metric ton of molasses. Full stop. The maximum yield in trial runs was 237.68 liters per metric ton of molasses. Full stop. Therefore, on 19th October 1994, the appellant issued a legal notice to the respondent claiming a sum of rupees 237.83 lakhs as damages. Full stop. As expected, the respondent disputed the said claim. Full stop. That is how the appellant invoked the arbitration clause by appointing its nominee arbitrator. Full stop. According to the appellant's case, a memorandum of understanding dated 24th July 1995 was executed by and between the parties without prejudice to their rights and contentions. Full stop. It provided for conducting one more trial run for 15 days after necessary modifications were made in the machine as suggested by the NCL. Full stop. The modifications were to be made by the respondent at its own cost. Full stop. By the MOU, the quantum of liquidated damages under clause 15 of the agreement was increased to 20% of the contract value, that is rupees 18.64 lakhs, which would be payable if the machine failed to give guaranteed performance. Full stop. According to the appellant's case, the fifth trial run conducted in August 1995 generated a yield of 224.54 liters per metric ton of molasses. Full stop. Both parties challenged the award by filing objections under Section 30 of the Arbitration Act, 1940, within bracket for short, single inverted comma, the 1940 Act, single inverted comma, close bracket, close, full stop. By a judgment dated 6th May 2000, the learned civil judge set aside the award and remanded the same for fresh adjudication by the arbitral tribunal. Full stop. Both the parties challenged the order of the civil judge before the High Court. Full stop. By judgment dated 20th October 2000, the High Court held that the claim of rupees 107.54 lakhs was beyond the jurisdiction of the arbitral tribunal. Full stop. However, the High Court upheld the claim for liquidated damages for the delay in delivery of rupees 2.09 lakhs, compensation for actual loss suffered in the yield of alcohol of rupees 21.42 lakhs, and arbitration cost of rupees 1.5 lakhs. Full stop. The appellant filed an appeal before this court against the judgment of the High Court. Full stop. This court set aside the order of the High Court and restored the order of civil court. Full stop. This court held that claim of rupees 107.54 lakhs and interest raised by the appellant was certainly arbitrable before the arbitral tribunal and was not beyond the scope of reference. Full stop. In short, the order of remand passed by the civil court was restored by this court. Full stop.